Greetings everyone, I am Rahul Mishra. Today I will be talking about legal and privacy issues related to computer forensics. Now before discussing about the issues, let's just recall what is computer forensics. Computer forensics is the science of identifying, analyzing, preserving, documenting and presenting evidence and information from digital and electronic devices, and it is meant to preserve the privacy of users from being exploited. Forensics specialists have a duty to their client to pay attention about the data to be extracted that can become possibly evidence. Essentially, it can be digital evidences investigation and way guiding to feasible litigation. Computer forensics has always been a field which is growing alongside technology. As networks become more and more available and data transfer through networks getting faster, the risk involved gets higher. Malicious software, tools and methodologies are designed and implemented every day to exploit networks and data storage associated with them to extract useful private information that can be used in various crimes. This is where computer forensics and security comes in. Now let us talk about the legal issues related to computer forensics. Use of computer technology in legal procedures necessarily gives rise to issues relating to security and privacy of electronically transmitted and stored information. Often in the course of a legal matter, information of a personal nature is disclosed, such as business, family or medical details. A natural concern of parties revealing such information will be to ensure that it is only used for a specific purpose and not unnecessarily disclosed or assessed. The potential for the unauthorized use of sensitive information is of increased concern where it is stored and transmitted electronically. This is due in part to the greater amount of information able to be stored and in part by new security risk to material when in electronic form. As well, it is important that there is some method by which the author of an electronic document can be reliably ascertained. In particular, for a communication to be relied upon, it must be possible to demonstrate with a high degree of certainty that the document has not been tampered with or altered in some way. It is important that such concerns are addressed in order to guarantee the integrity of any electronic legal system and to establish confidence in the reliability of the system. Without sufficient guarantees of security and a respect for the privacy of information, the development of electronic legal procedures is unlikely to be readily accepted by the legal profession and the wider community. Computers and the internet have become a pervasive element in modern life. This technology is also used by those who engage in crime and other misconduct. Effective investigation of these offences requires evidence derived from computers, telecommunications and the internet. The need for digital evidence has led to a new area of criminal investigation: computer forensics. Forensic investigators identify, extract, preserve and document computer and other digital evidence. This new field is less than 15 years old and is rapidly evolving. Education in this field has focused largely on its technical aspects. However, there are significant legal issues and ethical problems that investigators must deal with. Failure to follow proper legal procedure will result in evidence being ruled as inadmissible in court. As a result, a guilty criminal might go free. Failure to behave in an ethical manner will erode public confidence. Investigators must have working knowledge of legal issues involved in computer forensics. They must know what constitutes a legal search of a standalone computer as opposed to a network. What laws govern obtaining evidence and securing it to the chain of evidence is not compromised. What telecommunications may lawfully be intercepted or examined after they have been received. What legally protected privacy rights employees and other individuals possess. Because computer forensics is such a new field, investigative and legal norms are just now emerging. Little has been written about the legal requirements for admissibility of computer forensics evidence or about the ethical and regulatory issues related to this new field. First, we will examine the admissibility of evidence in a criminal prosecution, both with and without search warrant. The balance between the individual's right of privacy and the government's right to violate the privacy by searching and seizing property is defined as warrant. It is in frequent use in law enforcement today, as police searches and seizures must comply with its requirement. The magistrate may issue a search warrant if he or she is convinced that probable cause exists to support a belief that evidence of a crime is located at a premises. The officer must prepare an affidavit that describes the basis for probable cause, and the affidavit must limit the area to be searched and evidence searched for. The warrant thus gives the police only a limited right to violate a citizen's privacy. If the police exceed the limited right, or if a warrant is required but the police have not first obtained one, then any evidence seized must be suppressed. Suppressed evidence may not be used in court. In many cases, the criminal charges will be dismissed even though the guilt of defendant is clear. In a traditional old-fashioned case, a detective would receive information from a reliable informant that contraband, which essentially means goods that have been exported or imported illegally, for example drugs, was located at a premises. The detective would prepare a statement describing the informant's reliability and that the informant had recently observed drugs at the premises. The detective would take the affidavit to a judge who would determine whether probable cause existed. If that determination was positive, the judge would sign the search warrant authorizing the detective to search for and seize a specific type and quantity of drugs at that premises. The detective would then go to the location and execute the warrant. However, in a computer forensics case, there is added complexity. The contraband might consist of child pornography or records of drug sales. This information might be located on a laptop computer, but it might also be located on a network server in another state or in a foreign country. The information might be located on a hard drive or a CD. The contraband information might be very difficult to recognize. It could be encrypted, misleadingly titled, or buried among a large number of innocent files. It could take considerable amount of time to identify the contraband. As noted above, a search warrant gives only limited authority to the police to search. The search should be no more extensive than necessary, as justified by probable cause. Thus, if the probable cause indicates that the contraband is located in a file on a CD, this would not justify seizing every computer and server on the premises. The extent of the search is tailored to the extent of the probable cause. If the police wish to seize a computer and analyze it at a later time, the probable cause statement should demonstrate the impracticality or danger of examining the computer on the premises, hence the need to confiscate it and analyze it off-site. A new question facing law enforcement is when to notify the target of a search. Normally, the target is notified at the time a physical search is made. However, after certain updation in the law enforcement may now delay notification of the target for up to 90 days, with another delay possible upon showing of a good cause. In order to obtain authority for delayed notification, an investigator must show a need for the delay, such as danger to the life or safety of an individual, risk of flight from prosecution, witness or evidence tampering, or that immediate notice would seriously jeopardize an investigation. Another legal issue in computer forensics cases is how much time the police may have to analyze a computer after seizing it. Usually the police is given 10 days after issuance of the warrant to serve it. But there is nothing in the rule about how long the police may keep and analyze the computer. There was a case where a magistrate issued a warrant on condition that the police complete their examination of the computer within 30 days. When the police took 2 days longer than the allowed time, the court suppressed child pornography evidence obtained after the deadline. As a practical matter, the search of a computer in police custody should be done as quickly as possible. This is especially important if the computer is needed for the operations of business. Searching without a warrant. Usually for conducting a search and seizure in an area, the police needs a warrant, but there are certain cases or situations where a search can be conducted without a warrant. However, the reason must be admissible to the court. A search warrant is not needed if the target does not have reasonable expectation of privacy in the area searched. For example, the owner of a computer has a reasonable expectation of privacy in the information stored on that computer. However, if the computer owner transfers possession of the computer to a third party, for example for repair, that expectation of privacy may be lost because numerous repair personnel would then have access to the computer and its stored contents. Earlier non-computer cases suggest that when information is divulged, means make known to third parties, the expectation of privacy may be lost. The Supreme Court held that the expectation of privacy is lost when bank account information is divulged by the client, for example, revealing the OTP or one-time password. Cyber examples would include posting a message on an internet bulletin board or sending an email to a chat room. If circumstances suggest the sender had no reasonable expectation of privacy, then no warrant is required by the police in order to obtain that information. No warrant is needed when the target consents to a search of his or her computer. No warrant is needed where a third party such as a spouse, parent, employer or co-worker consents to the search, so long as the third party has equal control over the computer. No warrant is required when probable cause exists, but there is an emergency, leaving no time or opportunity to obtain a warrant. An example is where agents observed that the target was deleting files, so they immediately seized the computer. Privacy issues. Privacy issues have always been a major concern in computer forensics and security, and in case of an investigation, whether it is pertaining to computer or not always privacy issues appear. To enable privacy's protection in the physical world, we need the law that should be legislated, but in a digital world, by rapidly growing of technology and using the digital devices more and more that generate a huge amount of private data, it is impossible to provide fully protected space in cyber world during the transfer, store and collect data. Since its introduction to the field, forensics investigators and developers have faced challenges in finding the balance between retrieving key evidences and infringing user privacy. Privacy preservation from users' perspective. The major problem of preserving privacy is the lack of knowledge and understanding. General users do not know the technicalities of how networks and data storage are being managed and their rights in their personal and private information being used by organizations. Hence, researches and development of a framework and systems are focused more towards passive preservation without them knowing how the framework and system preserves their data. In instances where frameworks are applied to networks and databases, the solutions provided are usually effective in tackling situational crises on data privacy, and users usually do not know the solution are implemented to protect their data from being exploited. When users generally do not know if these tools work exactly like what they expect and assumed that they do work, private data are constantly under threat of being exploited by malicious parties with no warning post to the users to be aware of the situation of their private data. We also found that privacy preservation can never be achieved at its fullest. It is important for users to understand the need for them to secure their private information at the best of their interest, particularly when cloud computing technology is on the rise and more remote and shared data storages are made available for users. Users must know their responsibility in their own personal information and utilize as much as possible combinations of several developed privacy preserving solutions to protect their data while networking. From picking the right browser to perform private browsing to using the services of trusted organizations with proven functional privacy preservation policies and technologies in place are a few sets of decisions and combination of models and framework to secure private data better. We also think that users must always have the awareness and understanding that their private data might be leaked. Users must always be prepared to face scenarios and seek solutions when such leaks happen, and know how forensics investigators perform investigation without further threatening their privacy in this regard. It is also important that users are prepared to deal with situations when their privacy has been breached and seek the best solutions available, including forensics investigation. Data protection refers to the set of privacy laws, policies and procedures that aim to minimize intrusion into one's privacy caused by the collection, storage and dissemination of personal data. Personal data generally refers to the information or data which relate to a person who can be identified from that information, or data whether collected by any government or private organization or an agency. India presently does not have any express legislation governing data protection or privacy. However, the relevant laws in India dealing with data protection are the Information Technology Act 2000, also known as IT Act 2000, and the Indian Contract Act 1872. A codified law on the subject of data protection is likely to be introduced in India in the near future. Under Section 43A of the Indian Information Technology Act 2000, a body corporate who is possessing, dealing or handling any sensitive personal data or information and is negligent in implementing and maintaining reasonable security practices resulting in wrongful loss or wrongful gain to any person, then such body corporate may be held liable to pay damages to a person so affected. It is important to note that there is no upper limit specified for the compensation that can be claimed by the affected party in such circumstances. Under Section 72A of the Indian Information Technology Act 2000, disclosure of information knowingly and intentionally without the consent of the person concerned and in breach of the lawful contract has also been made punishable with imprisonment for a term extending to 3 years and fine extending to roughly 5 lakh Indian rupees. However, under Section 69 of the IT Act, any person authorized by the government or any of its officer specially authorized by the government, if satisfied, then it is necessary or expedient so to do in the interest of sovereignty or integrity of India, defense of India, security of the state, friendly relation with foreign states or public order, or for preventing incitement to the commission of any cognizable offence relating to above, or for investigation of any offence for reasons to be recorded in writing by order, can direct any agency of the government to intercept, monitor or decrypt or cause to be intercepted or monitored or decrypted any information generated, transmitted, received or stored in any computer source. The scope of Section 69 of the IT Act includes both interception and monitoring along with decryption for the purpose of investigation of cyber crimes. Case study on Uber Technologies. The scenario: in August 2018, the FTC announced an expanded settlement with Uber Technologies for its alleged failure to reasonably secure sensitive data in the cloud, resulting in a data breach of 600,000 names and drivers' license numbers, 22 million names and phone numbers, and more than 25 million names and email addresses. The settlement: the expanded settlement is a result of Uber's failure to disclose a significant data breach that occurred in 2016 while the FTC was conducting its investigation that led to the original settlement. The revised proposed order includes provisions requiring Uber to disclose any future consumer data breaches, submit all reports for third party audits of Uber's privacy policy, and retain reports on unauthorized access to consumer data. Second case study: Lenovo and Vizio. The scenario: in 2018, FTC enforcement actions led to large settlements with technology manufacturers Lenovo and Vizio. The Lenovo settlement related to allegations the company sold computers in the US with pre-installed software that sent consumer information to third parties without the knowledge of the users. With the New Jersey Office of Attorney General, the FTC also brought an enforcement action against Vizio, a manufacturer of smart televisions. Vizio entered into a settlement to resolve allegations it installed software on its televisions to collect consumer data without the knowledge or consent of consumers and sold the data to third parties. The settlement: Lenovo entered into a consent agreement to resolve the allegations through a decision and order issued by the FTC. The company was ordered to obtain affirmative consent from consumers before running the software on their computers and implement a software security program on preloaded software for the next 20 years. Vizio agreed to pay $2.2 million US, delete the collected data, disclose all data collection and sharing practices, obtain express consent from consumers to collect or share their data, and implement a data security programs. Cyber laws. Let us look into some important sections of the IT Act 2000. Section 43: penalty and compensation for damage to computer, computer system, and so on. If any person without permission of the owner or any other person who is in charge of a computer, computer system, computer network accesses or secures access to such computer, computer system or computer network, downloads, copies or extracts any data, computer database or information from such computer, computer system or computer network, including information or data held or stored in any removable storage medium, introduces or causes to be introduced any computer containment or computer virus into a computer, computer system or computer network, damages or causes to be damaged any computer, computer system or computer network, data, computer database or any other programs residing in such computer, computer system, computer network, disrupts or causes disruption of any computer, computer system or computer network, denies or causes the denial of access to any person authorized to access any computer, computer system or computer network by any means, provides any assistance to any person to facilitate access to a computer, computer system or computer network in contravention of the provisions of the Act, rules or regulations made thereunder, charges the services availed of by a person to the account of another person by tampering with or manipulating any computer, computer system or computer network, destroys, deletes or alters any information residing in a computer resource or diminishes its value or utility or affects it injuriously by any means, steal, conceal, destroys or alters or causes any person to steal, conceal, destroy or alter any computer source code used for a computer resource with an intention to cause damage. 43A. Compensation for failure to protect data, where a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource which it owns, controls or operates is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person. Such body corporate shall be liable to pay damages by way of compensation to the person so affected. Section 66D. Punishment for cheating by impersonation by using computer resources. Whoever by means of any communication device or computer resource cheats by impersonation shall be punished with imprisonment for either description for a term which may extend to 3 years and shall also be liable to fine which may extend to 1 lakh rupees. Section 66E. Punishment for violation of privacy. Whoever intentionally or knowingly captures, publishes or transmits the image of a private area of any person without his or her consent under circumstances violating the privacy of that person shall be punished with imprisonment which may extend to 3 years or with fine not extending 2 lakh rupees or with both. Section 66F. Punishment for cyber terrorism. Whoever with intent to threaten the unity, integrity, security or sovereignty of India or to strike terror in the people or any section of the people by denying or cause the denial of access to any person authorized to access computer resource or attempts to penetrate or access a computer resource without authorization or exceeding authorized access or introducing or causing to introduce any computer containment. Section 67A. Punishment for publishing or transmitting of material containing sexually explicit act etc. in electronic form. Whoever publishes or transmits or causes to be published or transmitted in the electronic form any material which contains sexually explicit act or conduct shall be punished on first conviction with imprisonment of either description for a term which may extend to 5 years and with fine which may extend to 10 lakh rupees and in the event of second or subsequent convictions with imprisonment of either description for a term which may extend to 7 years and also with fine which may extend to 10 lakh rupees. 67B. Punishment for publishing or transmitting of material depicting children in sexually explicit act and so on in electronic form. Whoever publishes or transmits or causes to be published or transmitted material in electronic form which depicts children engaged in sexually explicit act or conduct or creates text or digital images, collects, seeks, browses, downloads, advertises, promotes, exchanges or distributes material in any electronic form depicting children in obscene or indecent or sexually implicit manner, cultivates, entices or induces children to online relationship with one or more children and on sexually explicit act or in a manner that may offend a reasonable adult on the computer resource or facilitates abusing children online, records in any electronic form own abuse or that of others pertaining to sexually explicit act with children shall be punished on first conviction with imprisonment of either description for a term which may extend to 5 years and with fine which may extend to 10 lakh rupees and the event of second or subsequent conviction with imprisonment of either description for a term which may extend to 7 years and also with fine which may extend to 10 lakh Indian rupees. Section 67C. Preservation and retention of information by intermediaries. Intermediaries shall preserve and retain such information as may be specified for such duration and in such manner and format as the central government may prescribe. Any intermediary who intentionally or knowingly contravenes the provisions of subsection 1 shall be punished with an imprisonment for a term which may extend to 3 years and also be liable for fine. Section 68, power of controller to give directions. The controller may, by order, direct a certifying authority, any employee of such authority, to take such measures or cease carrying on such activities as specified in the order if those are necessary to ensure compliance with the provisions of this Act, rules or any regulations made thereunder. We will have a case study here. This was India's first BPO scam. The source in this case is Times of India. Life was good for John Verghese. The 31-year-old Pune resident had just returned from a holiday from Bangkok. Another Qualis was on the way to augment his loan taxi. Apart from his taxi business, John did other odd jobs elsewhere. Among a circle of young friends, mostly BPO employees in their 20s, newly acquired cars, fancy mobile handsets, handycams and jewelry were being flaunted. The present was great, the future bright. Suddenly, Pune police swooped. The rest of India and very soon the world awoke to India's first major e-banking fraud. The Mphasis Citibank funds siphoning case is particularly noteworthy because of the ease with which a bunch of young BPO employees from middle class, criminal free backgrounds allegedly pulled a financial fraud worth nearly $500,000 US. The 5 accused employees of MSource, the BPO arm of Mphasis BFL, included Unit Supervisor Moraline Fernandez, she was aged 25, Bijoy Alexander from Department of Human Resources, aged 26, and former customer care executives Ivan Thomas, aged 30, Siddharth Mehta, aged 20, and Stephen Daniel, aged 24, were no geek or hackers. They were not breaking through firewalls or decoding encrypted software. Instead, they are said to have identified glaring loopholes in the Mphasis system, devised a modus operandi, roped in friends like John from outside, and executed the fraud over 4 months. All this without Mphasis getting a whiff of what was happening. The scam may never have come to light but for Citibank New York and Citigroup Investigative Services Mumbai, which detected the fraud, did their own snooping and then urged Pune police to lay a trap. Mphasis Vice Chairman Sharon Tas said in an email interview from the US that there is no evidence of a breach or audit failure in the processes or systems employed by Mphasis and its client, as it happens to be a case of password or PIN sharing and compromise. However, in the light of this incident, we are conducting full external audits on processes and compliances. The Pune Cyber Cell, headed by ACP Sanjay Jadhav, has revealed that even Citigroup realized the legal fund transfers had happened through Mphasis only when former employees spilled the beans after being nabbed by the police being the authorized e-banking service providers to Citibank. Mphasis MSource employees were privy to confidential details of various account holders. The only pieces missing were the password or pins which the prime accused in the scam, Marlene and Ivan, allegedly got by sweet talking 5 account holders. People seem to have given these pins innocently. Once you give your house keys to the thief, there is bound to be havoc, says Jadhav. Having obtained the pins, the group allegedly opened fictitious email accounts to divert e-banking fund transfer confirmations. Thus, the original account holders never got the confirmation they would have otherwise got in the event of funds transfer. Neither Citibank nor Mphasis detected anything amiss after the first legal transfer in November 2004. In March 2005, a series of rapid fire wire transfers took place, with money being moved to about dozen bank accounts opened with the help of documents allegedly forged by John and co-accused Anand Kamawat an ICICI home loans agent. John and Karmawat are among one of the 16 arrested in the case who are non-BPO employees and whose role was largely to facilitate the illegal accounts. However, Citibank finally smelt the rat. After at least one account holder complained, it alerted Citigroup Investigative Services in Mumbai, headed by Rajendra Bhagwat. Bhagwat's team in Mumbai immediately touched base with the recipient banks in Pune and confirmed the fraud. The Pune Police's cybercrime cell was alerted and a trap duly laid. On April 1st, Ivan and a co-accused, Shailesh Bhulewar, came to check about a transfer in a Rupee Cooperative Bank branch in Pune. The police immediately swung into action and detained the suspects. There have been a total of 16 arrests since that day, with investigations throwing up fresh details virtually every day. Many of the accused have been charged under the Section 67 of the IT Act 2000 and Indian Penal Code Sections 420 for cheating, 465, 467 and 671 for forgery, beside other sections. The police say they have recovered about rupees 8.5 lakhs from Ivan, says his lawyer Harshad Nimbalkar, who is also representing 3 other accused. We will decide our defense once the police frames the charge sheets. Whatever strategy the defense adopts and whatever the outcome of the case, one thing is for sure, it is bound to be avidly followed, and not just by the BPO industry